Hi, Andy Nelson. I want to talk really quickly today about the three key elements of brand protection. And when I mean brand protection in this case, I'm talking about the symbols of your brand, meaning your trademarks. There are other things that kind of get wrapped up into your overall brand image. What makes you you. Your intangibles like your customer service and other sorts of things that you do that just that consumers associate with your brand. But I'm talking about brand protection in a very narrow sense, meaning the symbols, the trademarks or service marks of your brand. What are the three key aspects of brand protection in that regard? Number one, the first one is obtaining the appropriate legal protection. Okay, now trademark rights in the U.S. are created through mere use. Using trademarks helps build trademark rights in them. However, those tend to be limited, so elevating yourself to either state registered trademark rights, or even better, federally registered trademark rights give you really the maximum legal protection you can get. It doesn't create trademark protection, but it elevates or it enhances trademark protection. So the extent you can do that, and it's within budget, it is a smart thing to do. Because you get a lot of presumptions, a lot of added benefits from having registered rights, particularly federally registered rights. State rights, not that great, but federal ones, great. So element one, gaining the appropriate legal protection really is a key aspect of overall brand protection or trademark protection, okay? Two, this one's not so intuitive. Maintaining your rights by using them correctly, okay? So trademarks are built through use, but it has to be appropriate use and maintenance through appropriate use. So a lot of trademarks don't get used correctly, and they end up just kind of either having very thin protection or they end up fading away. So what I'm talking about, let's talk about brass tacks here. Trademarks, when you see them on products, they pop. They are bolded, they're set off from other text. They usually have a trademark notice next to them, like an SM or a TM, or if they're registered, you'll see that circle R. And they're used in connection with the product itself. It's not, I don't give you like blank packaging and then I go and talk about my trademarks on my blog or something like that. There's no real connection or, close proximate use, between the mark and the product. Here's a great example. This right here, this tumbler right here. This tumbler right here, the brand on the packaging. ICTech is the brand, okay? So that's great trademark use for a good. The trademark is on the product itself as well. That is fantastic use. Here you see ICTech with a circle R, letting you know it's a registered trademark. That's the kind of use I'm talking about. So your trademarks always pop. They're not used as, they're used consistently. They're not used as adjectives. Sometimes you add apostrophe S, take it away, or you make it plural, or misspell it, change it. All those sorts of things, if you're not consistent about your use and repetitive about it, can thin out your protection and dilute it. So that's number two. So once again, number one, obtaining the appropriate legal protection. Number two, using your trademarks correctly. The third element or aspect of trademark protection, brand protection in that sense, is enforcing your brand. And now I'm talking about third parties, not just doing what you can do, but also controlling what others are doing. So a lot of folks out there will have trademark rights and then it's like they just forget it. They don't do anything else. I got my registration or I'm using it and I'm done. You got to monitor the marketplace, okay? So if others are using not just your exact mark, but things like it in connection with similar goods or services or other circumstances that would suggest a connection between you and another party, thereby causing or likely causing confusion amongst consumers, you got to deal with that stuff. Now, sometimes you cannot deal with every single problem out there. The little minor ones may just be like mosquitoes, like I can't deal with that. You don't have to, but evaluate each potential problem for its severity, because you may have to take action. Sometimes you do it. It's not in budget. Yeah, but you know what? What's more important than your identity, your commercial identity? You got to protect your marks. So got to keep a fence around it. So make sure you're watching what others are doing, and as appropriate, deal with it. Sometimes it's nothing. Sometimes it's a letter. Sometimes it's serious enough. It might have to be a lawsuit potentially, but you got to enforce your rights. Or you've heard the phrase sitting on your hands. If you sit on your hands, you may have trouble enforcing your rights later when you really need to. Anyway, so those are the three aspects. If you have any brand protection, if you have any questions about this video, shoot me an email, drop a comment below. And if you think anybody else would benefit from the content of this video, please feel free to share it. Until the next one, have a good one. Bye-bye.